Welcome everyone to our webinar on data security compliance, legal strategies to avoid massive data breach penalties. My name is Estelle Nam and I'm a practice leader in LegalVision's disputes and litigation team. I'm joined today by my colleague Shannon MacDonald, who's a lawyer in our disputes and litigation team. Before we begin, a couple of quick housekeeping items. We will be recording this session today and you'll be emailed a copy of it. So if you miss anything, don't worry, you'll get a chance to look back later. We will also be taking questions at the end, so submit your questions in the chat box and we will try to answer as many as possible when we can at the end. Finally, there's a survey at the end, so we'll be grateful if you could answer them and give us any feedback. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today, we will be discussing your obligations under the Privacy Act, tips to avoid data breaches, and what to do if there has been a potential breach, and potential adverse legal and financial consequences. We will also look at recent updates on the privacy law after the recent major data breaches. At the end of the webinar, we will be answering some of your questions, so please submit your questions throughout the webinar through the chat function, and we will answer as many as we can at the end. Okay, now Shannon will speak to you about your obligations under the privacy legislation. Over to you, Shannon.
Thanks, Estelle. Good morning, everyone. So topic one, we'll cover obligations under the privacy legislation. So at the Commonwealth level, the Privacy Act 1988 sets out the laws governing information handling and privacy in Australia. The regulatory body is the Office of the Australian Information Commissioner, or the OAIC, which you'll hear a lot of, and we'll be referring to that body as the OAIC for the remainder of the webinar. It's important to remember that currently not all Australian entities are captured by the Privacy Act. You will have obligations under the legislation if you have an annual turnover of over $3 million, or you have a revenue lower than $3 million, but the nature of the business requires you to meet certain obligations. So, for example, if you provide health services or hold health records, you may have obligations, or if you're a contractor to a government, Commonwealth government department, or you're a credit reporting body. So what are your obligations under the Privacy Act? Well, there's 13 Australian privacy principles that set out how your business may collect, use, disclose, and store personal information and sensitive information. And those are available online, so you should familiarise yourself with those principles. The Australian privacy principles also set out access and correction rights of individuals and a requirement for regulated businesses to have a privacy policy and to include specific details in that policy. There's also obligations at the state level. There's state-based privacy and personal information protection laws that you must adhere to, depending on where your business is operating. If your business handles health information, you may also have obligations under separate state and territory-based health legislation, and locations that have health record laws may also apply to private sector organisations, which may actually also include obligations to report breaches to the OAIC. Legal obligations to deal with private information in a certain way may also be included in commercial contracts. You may also be subject to obligations to others under a contract with a third party, such as your insurance provider, and clients where you are required to sign their contracts. So make sure you read your contracts and understand your obligations. If you're an IT or a cybersecurity company, you should also be ensuring that your service agreements and contracts, such as determining whether a data breach has occurred, ensuring that those contracts are airtight and comply with the latest policies. In the event of a suspected data breach or an actual data breach, you may be required to notify your insurance provider. please ensure that you do read your insurance policy to understand what that says and make sure that you're not barred from making a claim. And recently, the federal government reviewed their privacy framework in Australia, and there were 116 recommendations made, including 2 noteworthy recommendations. Recommendation 6.1 was to remove the small business exception of $3 million in annual turnover. The proposed removal could affect approximately 95% of Australian businesses. Recommendation 6.2 was to reform the biometric gathering laws for small businesses, including prescribe the collection of biometric information for the use of facial recognition technology as an exception to small businesses, and removing the exception for the Act for small businesses to obtain consent in trade in personal information. Moving forward, we'll move to when you should report a data breach to the OAIC. If a data breach occurs, you are required to notify the OAIC of the data breach. So the next question to ask is, how do you determine if a notifiable data breach has occurred? So a notifiable data breach may occur if the following criteria is met. If there's been unauthorized access or disclosure of personal information held by an entity. So an example would be if someone gains access to a work computer that's not an employee, a breach may have occurred. This is likely to result in serious harm to any of the individuals to whom the information relates. So serious harm is defined as being serious harm to an individual may include serious physical, psychological, emotional, financial, or reputational harm. And lastly, the entity has been unable to prevent the risk of serious harm with remedial action. And the phrase likely to occur in this case does mean that serious harm to an individual is more probable than not to occur. And finally, it is important to remember that notifiable data breach can also occur if data is lost and it's unable to be retrieved. Types of personal information involved in a data breach is important as well. There are various types of personal information that may increase the risk of serious harm if unauthorized disclosure occurs. Sensitive information, such as information about an individual's health, documents commonly used to identify, so fraud, so Medicare cards, driver's license, passport numbers, etc. Financial information, or a combination of these types of personal information. The circumstances of the data breach. The specific circumstances of the data breach are relevant when assessing whether there is a risk of serious harm to an individual. This may include a consideration of the following: whose personal information was involved in the breach, how many individuals were involved, how long the information has been accessible, and who may have gained control and unauthorized access to the personal information. The nature of the harm that may result from the data breach is important to consider in assessing whether there's been serious harm. Organisations should consider a broad range of potential harms that may follow from the breach. Some examples may include identity theft, significant financial loss, threats to an individual's physical safety, loss of business or employment opportunities, humiliation or damage to reputation, and workplace or social bullying or marginalisation. The likelihood of serious harm occurring, as well as the anticipated consequences for individuals whose personal information is involved in the data breach, if the harm materialises, are relevant considerations. Further, it is worth noting that whilst individuals may be distressed or upset with an unauthorised disclosure or a breach, such a reaction alone is insufficient and in of itself to constitute an eligible data breach. So what should you do if there is a notifiable breach? An organisation or an agency that suspects an eligible data breach may have occurred, or if the breach, or if the data has been lost, you must quickly assess the incident to determine if it is likely to result in serious harm to any individual. The steps you should follow include step 1, to contain the breach. You must take immediate steps to limit any further access, engage a cybersecurity expert, preferably through your lawyers, and there's certain reasons for that. Step 2, you must assess the matter. Is it likely to result in serious harm? Consider remedial action. Take steps to reduce any potential harm to individuals, recover lost information, change access controls. If the remedial action is successful in preventing serious harm, entities may not be required to notify the OAIC. This assessment and remedial process must be done within 30 days. Step 3, notify. If serious harm is still likely, you must prepare a statement for the Commissioner. There's an online form via the government website, and notify affected individuals. Step 4, review the incident and take action to prevent future breaches. This may include fully investigating the cause of the breach, developing a prevention plan, conducting audits, updating security or response plans, and revising staff practices. Moving forward, just to consider penalties and consequences for a breach outside of the Privacy Act for a moment. In the past, the maximum penalty, this is related to the Privacy Act. In the past, the maximum penalty for a breach was $2.2 million. But after a series of major incidents, in November 2022, the penalty was increased to a fine of up to $50 million for a serious or repeated breaches, or 3 times the value of any benefit obtained through the misuse of information, or 30% of the company's adjusted turnover in the relevant period, whichever is the greatest amount. The consequences of failing to notify may result in the OAIC investigation and include a penalty under the Act. The Commissioner can order you to notify people at risk of suffering serious harm as well. Other consequences include class actions by individuals affected. For example, Medibank is the subject of a massive class action by the individuals whose data has been leaked. Other risk factors can include issues with your insurer and the time and money spent in dealing with the breach, including an OAIC investigation. When will the OAIC not penalise an entity where there's been a breach? Well, in order to limit the impact of a breach on affected individuals, Australian businesses should take remedial action where possible. If the remedial action is successful in preventing a likely risk of serious harm to individuals, then a notifiable data breach scheme notification and obligation may not apply, and the OAIC may not investigate or issue a penalty. So some recent changes to the case law outside of the Privacy Act. The decision of ASIC and RI Advice Group is a 2022 federal court decision. ASIC brought proceedings against the finance services company RI Advice, and the federal court found that RI Advice did not have sufficient cybersecurity measures in place, and ultimately the court decided that RI Advice was in breach of the Corporations Act and their directors' duties, and were ordered to pay $750,000 in legal costs to ASIC. And I will now hand over to Estelle to discuss what will happen when the OAIC does decide to investigate a data breach.
Great, thanks, Shannon. So as Shannon's mentioned, when there's been an allegation of data breach, the Commissioner may decide to investigate where the Commissioner thinks that there's been a breach of privacy or interference of privacy of an individual, or a potential breach of the Australian privacy principles, and it would be desirable to conduct an investigation. So it has a very broad power if it believes that it would be if it thinks that it is desirable to conduct an investigation. So what happens in a Commissioner-initiated investigation, and what actions could the Commissioner take after the investigation? If the Commissioner decides that there has been an interference of privacy, it might take a number of enforcement actions. For example, it can conduct an assessment of an entity's privacy practices and provide non-binding recommendations. It could require an entity to accept an enforceable undertaking and enforce that undertaking, direct an entity to take certain steps and bring proceedings to enforce the determination. It could also seek a court injunction to prevent a conduct that would constitute a contravention of the Privacy Act. It could also seek a civil penalty order in the federal court of up to $50 million for serious or repeated breaches. And the Commissioner may at any time also decide to discontinue the investigation where it's satisfied that no further regulatory action is necessary. And when will the Commissioner start investigation? So it might start investigation where there's been a complaint by an individual or an organisation. There's been a referral from another regulator or government body, where there's been media reports and getting public attention. There's been a report from an informant or a whistleblower, where it's identified a breach from another investigation. So what's the process? The Commissioner will notify the respondent. So it's going to display a notice on the Commissioner's website and that it's commenced an investigation. It will gather information and it will gather information if it decides that, and as part of the information gathering process, it could issue notice to produce some relevant information and documents and examine witnesses. So that could, if you don't comply with those notices or examination notices, you could be penalised for not complying with the orders. And then it will make a decision. So as part of the decision making process, it will form a preliminary view, and it might not take any further action if it decides that no breach has occurred or that it's been adequately dealt with by the respondent. It might impose an enforceable undertaking where the Commissioner forms the view that the respondent has failed to meet the requirements of the Privacy Act. It might also make a determination that could be published on the OAIC website. The Commissioner might apply to the Federal Court for a civil penalty order where there have been serious breaches. When will the Commissioner commence court proceedings to seek penalty order? So the Commissioner is not going to start legal proceedings unless it's satisfied that litigation is the only and most suitable method of dispute resolution based on the evidence gathered from its investigation, and that a civil penalty order should be made. So the most notable case where the Commissioner commenced proceedings in the federal court was against Facebook. It alleged that the social media platform has committed serious and or repeated interference with privacy in contravention of the Australian privacy law. The Commissioner alleged that the Facebook disclosed personal information of Australian Facebook users to an overseas app, and without consent of the users. So that's still ongoing and hasn't been finalised. Okay, so what's the recommended action to prevent breach, and how do you deal with the breach? So what are our recommendations? So it's important to firstly implement practical strategies. As Shannon discussed previously, the first steps you have to take when there's been an unauthorized access or if data has been lost, engage a cybersecurity expert to contain and limit further access. And you should engage a cybersecurity expert who has experience in notifiable data breaches. And you should promptly engage a lawyer to assess where there's been a notifiable data breach. And Also engage an experienced cybersecurity expert to investigate the cause of the unauthorized access. In the process, we strongly recommend that you communicate through your lawyers when you're communicating with your cybersecurity experts. There are reasons for doing this, and not many clients are aware of this. So communicating through your lawyers can be protected under legal professional privilege. Expert reports and materials provided for the dominant purpose of your lawyers providing legal advice to you as to the data breach can be withheld from production of documents when the Commissioner later decides to investigate the matter. But if you're not communicating through your lawyers, you will need to produce those documents. So if the cybersecurity expert finds that there has been poor cybersecurity practices in breach of the Privacy Act or the Australian Privacy Principles, which warrants penalty or legal proceedings, the evidence that the expert finds can be withheld from production and limit the evidence that the Commissioner can rely on to bring proceedings against you if you communicate through your lawyers. So once the cybersecurity expert starts preparing reports without your lawyer's involvement, those reports and data must be produced. And by the time that you find out, it's probably too late. So whilst it's not a formal legal requirement to maintain a data breach response plan, failure to have one can lead to serious legal implications. This is because the Commissioner will assess what, if any, remedial action was taken to mitigate the damage of a data breach. It will become relevant when the Commissioner decides to investigate the breach. How should you manage risks? The best practice is to manage risks so that breaches are prevented. You should implement processes and structures that protect your business from cyber attacks. Implement an incident response plan that identifies threat and impact, and that you can use to neutralize the threat by containing or blocking access, assess and repair damage. You should report you should report the breach where it is a notifiable data breach. You have to communicate with your customers, and after that, you have to reflect and learn. Identifying vulnerabilities and weaknesses. So you should make sure that you engage a cybersecurity expert to assess audit system configurations, identify weak or reused passwords, and make sure that that's dealt with. Make sure that people or employee practices are, you provide a frequent or regular employee training, and identify insider threats, and make sure that there's no poor data encryption. So the best way to manage cyber attack risk is to prevent them, and it's essential to have an incident response plan in place to allow you to act quickly and decisively. So an experienced cybersecurity expert will be able to provide you with that assistance. Okay, so the key takeaway from this webinar. So due to the recent ransomware attacks, laws have become tougher and stricter, more onerous, and directors can be held personally liable for data breaches. And most likely, the small business exemption will be removed in the future, and the Commissioner has broad powers to investigate, make determinations, and litigate to seek civil penalty. Therefore, it's important that you determine your entity's specific obligations under the privacy legislation. Ask yourself, are you an entity that has an annual turnover of more than $3 million? If not, are you one of the entities that handles information that requires stricter obligations and requirements? So implement a data response plan which allows you to act quickly to prevent serious harm. And if an attack occurs, engage lawyers to ensure that whatever damaging information that emerges from cybersecurity investigation is protected by legal professional privilege to minimize the risk of exposure to future litigation. Over to you, Shannon.
Thanks, Estelle. That concludes the main part of our webinar. You might find our notifiable data breach fact sheet useful. You can download that by scanning the QR code on the screen now or by accessing the handout panel of this webinar. We also have an upcoming event that may be of interest to you on copyright protection, protecting your brand, content and products. That's taking place on the Thursday, this is 12th of October at 11 a.m. and you can register at the link on the slide. We are going to be answering your questions shortly. Whilst you submit them, we'll take a minute to tell you about our membership. So LegalVision is a cost-effective alternative to have all of your business as usual legal needs covered. For a fixed monthly fee, you not only receive cost certainty, but all-inclusive benefits such as unlimited document review, which would include reviewing your commercial contracts, unlimited legal consultations, which means you can book as many meetings with us as you need to discuss your commercial contracts or any of your business as usual legal needs. You can talk to any of our lawyers, including franchising, corporate employment, etc., depending on your business's needs. And your membership offers unlimited trademark registrations in Australia for a very reasonable monthly fee, with options to purchase extra credits towards complex matters and ongoing disputes, which are charged at an hourly rate. Now we'll be answering some questions. I understand that we've already had some submitted overnight and we have had some more come through. So I will pass over to Estelle.
Okay, so I have a question here and I'll give that to Shannon to answer. So is there any difference based on the size of a company when it comes to protection of information?
The law says small businesses are not required to meet the obligations under the Privacy Act, but this is changing. Therefore, in reality, no. However, the scope and the breadth of your policy and remedial action plan will certainly become more sophisticated as the size of a business and network grows. For example, a more substantial company may have a dedicated CISO, which is a Chief Information Security Officer, and that may be implemented as it becomes necessary.
Great, thanks, Shannon. So I have a question and I'll answer this. What do we need to disclose to customers? So in terms of privacy policy, if you're an entity that's covered by the Privacy Act, you should publish your privacy policy and terms and conditions on your website and or any other in an easy to find location. And if you're collecting any information or gathering any information, that privacy policy should be easily accessible. The link should be at the footer of any location where your information is being gathered. Here's another question, and I'll give it to Shannon. Would working towards or achieving ISO 27001 or similar certification help?
Yeah, so look, the reality is that this landscape's moving very quickly. It's changing. And so depending on what jurisdiction you're in, you're going to have different obligations, to different parties. And so the best practice at the moment, if you're in Australia, is to be adhering to the Australian legislation. Now, if you're working in multiple jurisdictions, you'll obviously have to adhere to those other relevant countries' laws as well. And most of the policies that are being adopted by government are going to be derived from international standards such as ISO 27001. So whilst the Privacy Act for Australia requires that you comply with the Australian privacy principles, you should be certainly developing a network framework, policy and remedial action plan that's derived from a range of standards that includes ISO or the US National Institute of Standards and Technology, or NIST, cybersecurity framework, the Australian Cybersecurity Centre and the Australian Signals Directorate, so the ASCS Information Security Manuals, that's ISM. That's available online. Highly recommend you look that up as well. And any other relevant jurisdictions regulations, if you're operating across multiple jurisdictions, you're going to be legally obliged to adhere to multiple different regulations. Therefore, you would need a policy to adequately handle all of those legal requirements. It's important to note, so the for those that don't know, the ISO 27001 is an international standard to improve an organisation's information security management systems, whilst NIST CSF helps manage and reduce cybersecurity risks to the networks and data. Both ISO and NIST effectively contribute to stronger security posture. So I'll pass back over to Estelle for the next question.
Okay, thanks, Shannon. So I have a question here. What are the possible legal ramifications if I have taken all precautions recommended and a data breach still occurs? So that's a really good question. So whilst it's important to ensure that you're doing all you can to protect data and you have obligations under the law, and it's getting tougher and more onerous, the law doesn't require perfection. If you're complying with all of the 13 Australian privacy principles, have a remedial action plan, data response plan, and meet all of your reporting requirements under the Notifiable data breach scheme, the Commissioner will usually be satisfied that you have not breached the Privacy Act. So it's important to make sure that you're working with your lawyers, working with your experts to ensure that you're meeting the Privacy Act and the Australian privacy principles, and it's changing quite rapidly. So you might have a privacy policy that was drafted 3 years ago. You will need to ensure that that's regularly updated, and it's recommended that you work with your experts to make sure that they comply with the most up-to-date legislation. All right, the next question that we got, what's the best data governance framework for small business, startup businesses to mitigate data security and privacy risks? So I'll answer that. Well, the best approach is to ensure that you have a cybersecurity expert who has experience in this area, particularly especially those ones that recently dealt with the Notifiable data breach scheme or any OAIC investigation, and be guided by them. So if there's any breach, make sure to engage a lawyer promptly so you can minimize the risk of being taken to court. And actually, that was we received a question about why we recommend engaging a cyber expert through a lawyer when there's been a breach. I think I have answered that question already, but it's basically so that any damaging information that the expert discovers through the investigation is protected by legal professional privilege. And yeah, you can go back and listen to that again because I discussed it in detail earlier. Okay, so sorry.
We have some questions that have come through as well while you've been talking, Estelle. I'll give Estelle a chance to have a look at those. But one of them that I can address right now is an example where an organisation has, gotten it wrong in their response, which is a good question. Estelle and I have had an opportunity to be a part of a couple of substantial matters this year relating to OAIC investigations, and obviously we can't talk about those in any detail, but at a high level, an example where a company got something wrong that was important, which I think would be a good takeaway for this conversation, is when you do engage a cybersecurity firm or an IT company, having a clear understanding before a breach ever occurs as to what role and responsibilities certain individuals are going to take or have as part of penetration testing or audits, or if a breach occurs during the investigation. And one issue that arose during one particular matter that I was a part of was a misunderstanding between two individuals or two corporate entities as to who was to be taking the role of CISO, the Chief Information Security Officer, and what responsibilities that position would have. And that can become a major problem when it comes time for the government investigating, and there's uncertainty as to who is the individual that has a responsibility for actually making the determination as to whether a notifiable data breach has occurred. Estelle?
Yep. All right, so we have a couple of more questions, but but some of them are a little bit more complicated, and we are happy for you to book in a free consultation. So you can provide your details at the end of the webinar in your survey, that you request a consultation. And we're close to running out of time, and so we're sorry if we couldn't get to all of your questions, but certainly we can have a consultation afterwards. So that's all we have for today. So after the webinar ends, a survey will pop up. We would really appreciate if you could complete the 30-second survey. So please include your contact details to receive a complimentary legal consultation to discuss how we can help you with questions on cybersecurity related issues or your obligations under the Privacy Act. Thank you.
Thank you.